Our fifth case this morning, Jacobson versus the Commissioner of Internal Revenue.
Good morning, Your Honors. May it please the court. I represent Mr. Jacobson, who, despite an extreme disruption... I remember being nervous once I stepped in, the way the place is set up. I have a feeling it's deliberately set up to give you a sense of the weight of where you are in.
The ability to argue a case before United States Circuit Court is an amazing opportunity for a law school student. Very few get that opportunity even after they graduate. So the chance to make this oral argument is especially important for the students in the tax clinic, and I think any of the students in the clinical programs at Harvard.
Counsel, whenever you're ready, please proceed. Ready?
Yes. Mr. Chief Judge, may it please the court. My name is Adeyemi Adediran. I represent the appellant. Today we have a case involving a veteran, one who presently suffers from PTSD.
Mooting is an important tradition in the legal profession. Lawyers moot, and in our clinic we moot the students every time we have to do an argument. Without mooting, you would not have the same effect for getting prepared. You wouldn't hear questions, you wouldn't hear yourself answer. So mooting is extremely important in the preparation for an oral argument.
Just to zoom out from the case itself, you have a very nice manner up there, which is, it's respectful but firm. The one thing I would suggest though is that, and I know it's comfortable, but you were doing this, it's comfortable, but I don't think courts generally, they want you to be, you can still use your hands and be very, very natural, but you don't want to lean on your podium.
So this is a case involving a veteran who had been married to his wife for a couple of years. The wife got caught for embezzling. Both of them, because they had been filing jointly, were held responsible for the embezzled income that had not been reported, because according to the Supreme Court, if you embezzle money, you're supposed to pay taxes on. There was no way for him, just looking at the account, the joint account that he has with his wife, there was no way for him to look at that and determine the embezzlement income implicated in the present analysis.
So Mr. Jacobson was a worker at a cheese factory, and his wife was a bookkeeper at the Appleton, Wisconsin blood bank. Over the course of 3 years, she embezzled $500,000. He did not know about her embezzlement until the third year when she was arrested and sentenced to jail. But most people don't know that embezzlement creates taxable income. And Mr. Jacobson also didn't know how much money his wife had embezzled.
We are, as you know, a court whose job is to look for error below. What, in particular, are the errors that you say the tax court committed?
We have here an application of a balancing test. Actual knowledge is not to be overweighed compared to other factors used for determining relief for taxpayers.
When you're seeking innocent spouse relief, there are 3 ways to get innocent spouse relief, but the one that we were seeking was equitable relief. And under that provision, the Internal Revenue Service has adopted 7 factors to be looked at.
Here you have the tax court deciding to use just one factor has been sufficient to prove that a taxpayer is not eligible for relief. And that's the error.
If we didn't take these cases on appeal, most of our clients would probably end their case at the tax court level. So our pushing them and representing them in the circuit court is their opportunity to have their voice heard at a higher level and the opportunity to overturn the adverse decision that the tax court has rendered against them.
We had the opportunity to watch a couple of people go up and argue before we did. And so there was a range of performances. Some people did really well, some people were awful. And as a student watching lawyers who've probably been practicing for several years, having different experiences during their argument, began to take away some of the nervousness for me. But it was very difficult for any layperson to determine the exact amount that was owed for 2011. In fact, when you look to the record, you'll find that the IRS agent herself, who made a determination as to how much was owed, found it very difficult to determine the amount for 2011. So of course, Mr. Jacobson...
One of the judges was appearing by video, and the video screen was only a couple of feet from his face. So I think he was a little intimidated by that. But after a moment or two, he hit his stride and made a very good oral argument, equal to the oral arguments of almost anyone that was there that day.
Coming here to a new country, I moved here 6 years ago. I wasn't sure that I would have the capacity to do well as a litigator. Not because I didn't think that I had a mental capacity and all of that, but the communication aspect of it bothered me. And I envisioned that someday I would overcome what I thought to be that limitation, that communication limitation, and one day do what I did recently at the Court of Appeals. And that it has happened so soon. It's big for me, and I don't think that I've actually told anyone that. But it's been a wonderful journey, and I'm just grateful.